This room can sometimes be the best space, depending on what's going on, and sometimes the most awkward space. So our guest, Mr. Jordi Palou, will have to lean to the left to talk to most of you. Well, welcome. Thank you for being here. Let me introduce to you our very special guest who comes to us, just arrived from Barcelona, Spain, Mr. Jordi Palou. Mr. Palou comes from Spain, where he is a lawyer, mediator, and national international conflict resolution consultant. He holds a degree in law and a master's in criminal law from the University of Barcelona, a master's degree in mediation and conflict resolution from the Ramon Llull University of Barcelona. Believe me, that was hard to pronounce. That's how it's spelled.
It's Catalan.
He is currently working on his doctorate, his PhD. He is the co-director of AEQUITAS, a mediation and alternative conflict resolution service that provides services for a number of legal issues, including family law, criminal law, and international and local conflicts. He is the lead attorney in his own law firm of Palou and Rognoni Associates Attorneys at Law. The firm specializes in family law, criminal law, and again, international and national issues. He teaches mediation, conflict resolution, and transitional justice at various Spanish universities, including the Ramon Llull University, the Autonomous University of Barcelona, and the Balear Island University. He's a member of the Barcelona Bar and the Human Rights Institute of International Bar Association, among other national and international human rights NGOs. He's a member of the International Criminal Bar and a lawyer at the International Criminal Court based in Den Haag. 2004, he was awarded the first prize of the Catalan Association for the development of mediation and arbitration when marking its 10th anniversary with his research entitled Mediation and Conflict Towards a Harmonious Boomerang. He's written extensively, publishing various articles and books in the area of international law and mediation. In 2002, and since that time, he's assumed the legal representation of Catalan, Spanish, Rwandese, and Congolese victims in the conflict in Central Africa, as well as of the International Forum for Truth and Justice in the African Great Lakes. He's met with victims, relatives of victims, witnesses and experts in Europe, Africa, the United States, and Canada. And before I turn it over to him, let me say that personally it's a great pleasure to have him here because he has agreed to work with Dean Brian and myself to explore the possibility of offering to our students externship opportunities in Barcelona, Spain. We got a little late start this year, although with his help and the help of an alum from Whittier Law School who lives in Barcelona, we were actually able to secure a commitment from quite a number of firms and institutions in Barcelona. So we're going to take our time, pace it a little slower, find out more about what our students can do there and how to coordinate those efforts with what we're doing here. And we hope to really launch a program next summer, 2011. So if you are around, hopefully you might be able to consider that. So without further ado, I turn the floor over to Mr. Jordi Palou. Thank you, Jordi.
Thank you very much. Good afternoon to anyone. First of all, I would like to thank the School of Law of Whittier, and especially Dean Ms. Brian and also Calvin for inviting me and to stay with you. It's really a pleasure and an honor to be invited to share a little bit about our vision. And I'm glad that Professor Webster and Professor Madsen also are Madsen present here, and he's got a great experience in practicing law in Spain, so in some way he will be here to complement and even to give his vision about that might interest all of you. And I would like also to thank not only the Dean and the the assistants, Mary and Catherine, but also Juliet Kent, who is a former student of that university, and in a way she contacted us with all of you and made also possible that we are here with you. So we are grateful. We thank you very much. And to start, of course, we are almost in family, so I think we can share pretty informal, and I'll try to give some key ideas of the practice of law in Spain, but again, what I think would be most interesting for all of us is to share about your comments and your questions and whatever you find interesting to share with us. I saw your website about the mission and the values and the history of the Whittier College, and I'll try to, in a way, focus on that also, because I really find this is very, very interesting and very, very important. You say that you are actively involved in local community and the global community. Much of that we're going to share tonight and also tomorrow in the two lectures that I'm going to give tomorrow. And knowledge and understanding, I think that is the present and the future in our relation. So in a way, I will try to focus on that, and from that, of course, what's been a little bit the practice, the history, but the present conditions and the future for the practice of law in Spain, especially for those who are in a way interested in what Professor Pilar has proposed to you as an internship for this year and then in the years to come. So, to give you some key ideas of what is practice of law in Spain, first thing I have to say is that we have to put our law practice in context. As Professor Pilar was saying, I'm coming from Barcelona, and Barcelona, just for you to know, it's a city town that it's in the Mediterranean Sea. It's the capital of Catalonia, a little country in the east of Spain. And we were visited very, very early by the Greeks and other cultures and other communities. But Barcelona as a city town was established at the first century with the Romans. So especially in not only in Barcelona, but in the surroundings, we were very, very influenced by the Romans and their knowledge, and of course their practice of law. And what we have to consider that very, very close to Barcelona, we had Tarraconensis, which was one of the main provinces of Rome at that time. Centuries after, we've, as a little empire that we were in the Mediterranean Sea, we had really a great exchange with other cultures, other communities in the Mediterranean, especially on commerce and trading issues. And that brought, to make some history, a well-known institution called Consolat de Mar, which was, in a way, a good precedent of arbitration and mediation in commercial issues in the Mediterranean at the beginning. And so this is a little bit of some spots of our history. After all, we were part of our unity with our kingdoms in Spain, different part of Spain and different traditions. We had at the beginning our own language as a country. We had even our own institution. We had our own little constitution at the beginning. We had our own parliament. So we had also our own local laws as a little country. And since our high responsibles were married with other kings, they started to have also influence from other perspectives. And this comes in a way of one of the main, maybe complementary differences that we have that comes for us to explain why Spain, and Catalonia in particular, but Spain in general, belongs to this Roman Germanic tradition, which is a different tradition, as you already know, about your what we call common law or Anglo-Saxon tradition. And as I will say probably in some different moments today and tomorrow, in my opinion, this is becoming to really have mutual and very, very intense influence between the two legal systems in the world. Probably one of the last examples of that is, in fact, the statute of the International Criminal Court, which in a way is a good experimental, we will see if it's good or not, but at least it's an experimental mixture of these two main traditional law and practice systems. And as you know, the Roman Germanic tradition, or the civil law as it's known, it's based basically in the law, in the previous law, in the establishing the law previously to a general situation, and which in a way it's a different perspective from the jurisprudence and from the case-to-case study that mostly Anglo-Saxon tradition you have. And of course the differences comes from many aspects and of course history, but especially I would say two main aspects, which are probably the different role of individual and the community, and the relationship between the individual and the community, and also, which is maybe also different, the role of the state, whether it's more interventionist or less interventionist in the private relationships and the public relationships. Later on in the 19th century, we had the process of codification, which is in our system a very important moment. For instance, our civil code is about 2 years later of your college or your school established. It was in 1889, which in a way is the basic skeleton of our system, which in a way takes many institutions of Roman law. And we have in our system our constitutions and also our codes, which in a way establishes the legal system that has been modified since then in various ways, but also respects many of the historical procedures and practices, both in private law and public law. So, of course, we can later on share on that, but we could consider both systems that have positive things and risky things. And probably this is one of the real motivations that is why the both systems are influencing one to each other. I will just outline some. as a positive thing for the civil law or the Roman Germanic system, I would say that there is a pre-established law, and like that, people, individuals and communities, and also corporations and organizations, in a way have a sense of legal security that was established by the law previously. And one of the main columns of that is to provide equal rights for everybody, which is, in a way, very important and very difficult. But this has also a risky situation of many various risky situations, and we could have different visions about that in the sharing. One of the main risks of that civil law system may be the law proliferation. This means that there's an incredible amount of laws that are being approved and are being established by different corpses, as state corpses, or what we call autonomous region corpses, or even at local levels. So many laws are studied and passed, and this is a real risk for what it was positive, the legal security, because at the end there's a little confusion, or sometimes a big confusion, by individuals and communities and organizations. What is the law that is being passed, or it's enforced in a very particular situation? And another risky situation, if we compare to your system, may be that this pre-established law provides general decisions, which not always are accurate to very concrete situations, because of these equal rights and general perspective that the general law for the general interest have as a focus. And maybe I'm wrong, but I'll try to outline what I see positive, or key things that I see positive in your system, and risky also situations for the Anglo-Saxon system or common law system. I would say two key points is freedom and minimum intervention of the state as a dynamic which is present from the beginning. And secondly, maybe this concrete case solution focusing that allows really accurate decisions and solutions to a very concrete problems that are submitted to courts and justice. And maybe a risky situation, it might be in definition in some cases because of that, because of the lack of general laws and general acts that are being provided, and maybe in a lack of general view in some cases. So in a way, these positive and risky topics or points that I've outlined, that there are many others, of course, I think it's the main motivation and the main reason of why these two systems are trying to influence each other, and why maybe common law systems are trying to, in a way, establish new acts and laws general provided, and why our system of civil law tries also, according to the jurisprudence, to focus also in very concrete solution perspective. So from that, and now entering a little bit in the practice of law in Spain, from all that very short historical perspective that I've shown up, Our main jurisdictions in our practice could be outlined as civil and commercial first, criminal as a second, both in adults and minors and juvenile justice. What we call third, contencioso administrativo, which is administrative, which relates from the special relation from individuals and organization with administrative and public institutions, and also fourth, labor law courts, sorry, which in a way focus on labor relationships. These four mainly jurisdictions, which maybe there are links also with your system, we can see them at different levels, so at different local and province and regional levels, and also national level. And I would say, just to introduce very shortly, because I'm going to speak a little bit of that tomorrow, that for criminal, for instance, and for administrative, and also for laboral and civil, we have a national perspective, and what we have the Supreme Court, of course, but we have also different national court, which is called Audiencia Nacional, which is national court, let's say like that, which is competent for criminal procedures for crimes who has a national